Good morning and welcome to today's webinar, The Essentials of Estate Planning and Elder Law, presented by Elville and Associates Managing Principal and Lead Attorney Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and I'll be moderating today's event. We have many new attendees to today's webinar, so welcome to everyone. And if you're returning to see us again, thank you for your continued support as always. So currently you as the attendee are in listen-only mode for our webinar today. However, if and when you have questions, please note them in the questions panel on the right-hand portion of your screen, and we will take time throughout the presentation to address them. Your questions really help the presentation and add value. They help others learn, so please don't be shy in posing your questions at any time. You received the presentation yesterday by email from me to take notes on it if you wish. If for some reason you did not receive the presentation, it is available in the section marked Handouts in the panel on your screen to download at this time. For our professionals on today's webinar, welcome as well. For CFPs, CPAs, and other professionals, you may receive 1.5 continuing education hours for attending. And per my attendance records requirements, if I don't have it already, please email me your ID number. And for CFPs only, I also must have the last 4 digits of your social security number as soon as possible so I can submit your CE hours for approval. Everyone will also receive a post-webinar feedback email right after the presentation, and we do ask that you please just take a couple of minutes to offer us your feedback about the presentation, and we read and value every comment. It's also an ideal time to request a consultation with Steve for any planning needs that your family and you may have. And here at Elville and Associates, we always look forward to being a resource to you now and in the future. So very briefly, as we have a lot to cover, I'd like to offer you an overview about our firm and share just a little bit about Steve as well. So you should be able to see my screen, or maybe not just yet. There we go. So Elville and Associates, we were founded in 2010 by Managing Principal and Lead Attorney Stephen Elville. We have a number of different practice areas here at the firm that we work through: estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, and tax planning and asset protection. We have 7 attorneys, 12 staff members, and 5 locations, and Steve and I are coming to you live from the Columbia Gateway Community location here in Columbia. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. We do offer a lot of education here at Elville and Associates, and we do that in several ways. We do that through our planning processes with our clients. We do offer over 100 educational webinars and workshops in the communities that we serve each year. And also by way of our accredited client care program. We are one of only 2 firms in Maryland to have what we call a CCP, accredited by the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion in mind with every client every day here at our firm. A little bit about Steve. His work as an attorney for the past 20+ years has been centered in elder law, special needs planning, and estate planning. He's a member of the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. And he works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. A very seasoned speaker, if you haven't heard Steve present, offering many webinars, workshops for businesses and their employees, conferences, and continuing education events each year. Also named to the Maryland Super Lawyers list for his 7th time in 2022, so congratulations to Steve. And also had a feature story written about him in National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014, and I am privileged to be the executive director of. So if you'd like to learn more about the Elville Center and the work that we do in the communities that we serve, and we work to make a musical difference in the lives of children each day, please reach out to me and I'd be more than happy to share our story with you. So with all that said, we're going to go ahead and get started here. We have a very brief poll that we'd like to offer. just to get a little bit of information about you, our audience, and see what's brought you here to learn today. And simply, the question is, what brings you to today's webinar? I'm going to go ahead and launch that poll. And the choices are, 1, I am new to estate planning and need to get started. 2, I have a plan in place, but it is outdated and needs updating. 3, I feel my plan is on solid ground, but education is always great. And lastly, I'm an advisor here to learn to better serve my clients. So take just a second to make the choice that best suits your situation, and we'll go ahead and get started. While we're doing that, Steve, I'm going to go ahead and make you the presenter so you can share your screen. Okay, with most of the choices being submitted, we have 26% saying I am new to estate planning and need to get started. 23% say I have a plan in place but is outdated and needs updating, which is not unusual. We see that a lot here at the firm. 21% say I feel my plan is on solid ground, but education is always great, which it is. And 30% say I'm an advisor here to learn to better serve my clients. So thank you all for joining us. I'm going to close that poll out and we'll go ahead and get started. Steve, did you go ahead and looks like you're the presenter. I don't yet see your screen up.
All right, I had a little technical detail going on there, Jeff, and I'm just trying to reconnect. I'm going to try to share or get control of the screen here.
Maybe I'll take that back and try to get back to you. Let's try that.
All right, there we go. That looks familiar.
There we go.
All right, thank you so much, Jeff, and good morning, everyone. I'm just going to get my slideshow started here. Welcome to our Friday webinar, and welcome back to our webinar series in general. It seems like August has in some ways been slow and other ways has been fast, and here we are at the end, and it's almost September. So welcome, everyone. It's my privilege to be here with you today. I'm looking out my window here in conference room 3 of Elville and Associates at Columbia. And lo and behold, it's a beautiful day. And it, again, is just my privilege to present to you today with Jeff, my trusted colleague and someone I've worked with for many, many years. And Jeff is an expert moderator. He's going to take your questions. He's going to let me know if there are questions. He's going to solve any problems that may arise, which we hope we don't have any. And just feel free to utilize Jeff and to understand that this is an informal presentation in a way that you can ask questions at any time. And I attribute a lot of what we've been able to accomplish here at Elville and Associates to our associates and devoted employees, and I just thank them all. And I thank you for sharing your very, very valuable time with us on a Friday morning. So with that said, we have a lot of material to cover. My objective here today is really to lead you through a discussion to help you think in terms of the real essentials, the fundamentals of estate planning and elder law. And it's a lot of information, but I want to assure you that if you feel overwhelmed at any time, I want you to know that the good news is you'll be able to have this PowerPoint presentation as a tool for yourself. You can always reference it. And I promise you that if you can get the gist of most of this material, you will know 95% more than anyone you know about estate planning and some of the fundamentals of elder law. So that's my promise to you. And here at Elville and Associates, we're committed to education. We feel we're one of the only law firms that is really dedicated to real substantive information and education for clients and making sure they understand all of their choices in estate planning. So along those lines, I'm going to characterize this presentation as maybe a master class or a mini master class about estate planning. This presentation is the compilation of my experience and everything that I've been able to compile and try to put that to within an hour to an hour and 15 minutes of this presentation. So I promise you're going to walk away with substantive things that you can learn and you can use. But over the years, we have found that educating clients is not enough. It's really great, and it's something that we believe is our value proposition. It's something that we really live by each and every day. But we also know it's important not to just educate, but it's important to give clients and prospective clients a path forward, a way for you to engage and be able to move forward and not just have tons of information at your fingertips, but something practical to move forward with. So we promise we're going to give you that opportunity to move forward and get your planning reviewed or get your planning done if you've never done any planning. And I know there are various people on this call and various states of perfection or not perfection, or having an estate plan in place or not having an estate plan. So with all that said, welcome, and we're going to move forward now. So we're going to talk about the following things today, and we're going to get through these bullet points. What is an estate plan? What is it? And what is the process? And you'll notice that I have included the word process. And for those of you who have never seen this, estate planning doesn't always have a process. And we here at Elville and Associates believe that it should have a process. A real transactional type of arrangement, which we're going to talk about in a few minutes, is just not going to be enough in 2022. We have too much going on in the world, too many changes. Life is too fast and fleeting. There's lots of going on in the world, politically, economically, sociologically. So we want to have a process. Now, some estate plans can fail. They can fail, believe it or not, they can fail to work as we intended. And that may be shocking to some of you, but we want to get right up front with that if you don't approach your planning in the right way, with a process and with goals in mind, then we could be looking at a situation years from now at your passing or upon your incapacity where the estate plan doesn't work the way we want it to. And that's not what we want. Now, one of the biggest questions in estate planning all over the United States and honestly all over the world is, what is the difference between wills and trusts? Now, knowing that is the big question, one of the things we ask ourselves is, how do we understand probate, which is really the issue of wills, versus non-probate, the issue of being able to pass assets without probate? So we're going to talk about the difference there. And then as we get in the more depth, we're going to talk about the concepts of elder law, concepts of taxation, concepts about asset protection, how to protect yourself from the claims of creditors, how to protect spouses if they were to remarry, and protect the children if you're married or have children from making sure that a new spouse cannot cause issues. All of those kinds of things we're going to talk about. And as I mentioned, we're going to give you a path forward and how to get started, how to take the next steps. So there are many reasons why anyone, whether you're single, married, no matter what sex or age you are, many reasons why to plan. But we have to have a goal. So I wanted to say at the outset, all planning, whether it is estate planning, whether it is elder law planning, whether it's special needs planning, whether it's tax planning, charitable planning, whatever it may be, you need to understand what your goal is, your why. So here at Elville Associates, we want you to have a goal. And many of you may not have thought about this, and your goal may be something that is developed over time. For example, it may take a few meetings if you become a client. It may take a few meetings to understand what your goal is. And we want to understand what the end goal is. The end goal is to make the plan work the way we want. You know what you know today. I know what I know today about my family, my situation, my financial affairs, and we plan based on what we know today. But our goal will carry us further than today because life changes. There are situations that occur in the future that we may or may not be able to control. And we need to understand our goal as guidance into the future. Why do plans fail? We're going to talk about that as well. That's part of the understanding of putting a plan in place and then making sure we follow our goal into the future. So I want you to have a purpose, I want you to have a goal, and I want you to start thinking about that. If you don't have a purpose or you don't know what your goal is, many times I want to assure you that goal will kind of come to you. It'll bubble up to the surface while you are doing planning. So the process will drive information and education, but it also will help you understand what your goals are and how you want to achieve them. So many people, just to give you a few ideas, many people plan because they just want certainty, right? We're living in an uncertain world. COVID-19, all of the things that have happened in our country in the last few years, people are uncertain. So clearly, planning is about providing for certainty. Some people want smooth administration. Well, Steve, I'm planning today, but I'm also looking to the future. I'm looking to, when I pass away, I want to have real smoothness, or real fluidity in my administration of my estate. Some people are focused on minimizing the cost of administration. I don't want probate because maybe it's too expensive ultimately, or in theory. I want to avoid that expense. Some people look at the total cost of planning as how much does it cost to get planning, plus how much does it cost to administer the plan. And I think that's a very good way of looking at it. Some people are focused on asset protection. We talked about that just a little bit. Protection for spouses, protection for children from divorces and bankruptcy and those kinds of things. Protecting grandchildren may be important to some of you. Some people are focused on taxes. We want to eliminate taxes. Fortunately, we're living in a very tax-friendly environment across the country for estate planning. And some of you may have special personal reasons for planning. It could be a special needs loved one. It could be something that's very personal to you that is the object of your planning. So this is really where we want to start. Now, I've mentioned this a couple times and I'm not going to continue to emphasize it, but there is a possibility that our plans won't work. To give you an example, if you look at this bottom blank space that I have here, many people do not do estate planning. So I'm going to give you the statistics as I think we know them. How many people on a percentage basis of 100%, how many people in this country do estate planning? So first, let's talk about the people who don't do estate planning. So I'm going to give you the answer. It's about 55% of people do not have any kind of estate plan whatsoever. So that's something you want to think about. And that goes up depending on demographics. So the 55% can go up to maybe 62%, something like that for divorced people and other demographics. So that's quite a few people who don't have any planning. That means that only about 45% of people actually do planning. So a minority of people actually do estate planning. Now, going back to this last bullet point down here, of those few people who actually do planning, how many years go by between the time those people who did good, they did their planning, and how many years go by between the time they actually follow up with those plans? And we find out statistically that it's about 19 years at a time. So this may be shocking to you. So think about this real quickly, and this will be the point I'm making on this slide. If we do planning, which means we've done very well, but we only follow up every 19 years, is there a possibility that our plan will not really work the way we intended? Yes, obviously, very common sense. There's a very big possibility due to changes in the laws, changes in family situations, changes in health. Our plan simply cannot possibly work right if we don't follow up. So this gets back to the first couple of bullet points here. We don't want to treat our planning as a transaction. We want to have a full process. So traditional estate planning, which is how I was taught in estate planning when I came out of law school, traditional estate planning is very transactional. Clients are met with on a very quick, relatively quick basis. Documents are exchanged, and that is the plan. There is no further follow-up. There is no further education, generally speaking, and that's the basis for all mistakes. We might have a great plan in the beginning. It looks great. We have great documents, but over time, things may change. Our life circumstances change. And if there's no continuous follow-up, if there is no education, if there's no education for children, nieces and nephews, grandchildren, trustees, then we may have a plan that's really not going to work. What we want, as I've said, is a process-driven plan. The traditional plan, again, only has one phase. I'm not going to focus on this because it's in your materials. But the process-driven plan, no matter how many steps there are, whether there's 3 steps, 6 steps, 10 steps, what matters is that there is a process. And just to give you a little clue about this, we want plenty of time. We don't want a quick process. We want plenty of time to think about our planning. What are our goals? What is the design of the plan? And then we want to implement that plan. This is the correct way to do planning. Maintenance and updating. The first thing that I think about when I think about maintenance is, oh my goodness, I don't want to do maintenance. I don't want to do maintenance on my car. I don't want to do maintenance on motorcycles or whatever else there is to maintain. But many of you do enjoy maintenance, but generally that is not something we want to do. But in estate planning, we have to look at it as over the years after we put our planning in place, we do need to maintain our plans. We do need to have a relationship with our estate planning attorneys, because if we don't, life will take us down the stream, take us down the river of randomness. And we all know what happens in our lives when we get distracted, and then years can go by and we did not maintain our estate plan. So Elville and Associates is committed to the design and implementation of your estate plan and the maintenance and updating of your estate plan. And now, even though we don't like to talk about this, at the time of our passing, now we have a plan that will actually work at the time of the administration of our estate. So a process-driven plan is what we believe in and what we are all about here at Elville Associates. And these slides talk about that, having a process versus not having a process. And we definitely want to plan with a process. We also want to collaborate. I'm going to go into a different direction here just for a second. We want to collaborate in that process with your financial advisors and with your certified, your CPAs, your certified public accountants, whoever prepares your tax returns, maybe even an insurance agent. We want to have a collaborative process. So if you don't have a collaborative estate planning team that includes a financial advisor or includes a CPA, we want to help you to get that, because we believe in that collaborative approach and the model of caring for clients. Now let's define estate planning. Estate planning can be defined in many, many different ways, depending on who you are, your status, or where you're coming from in life, okay? I'm going to give you a very basic definition this morning, and you may want to write this down. Estate planning is about disposing of your property, disposing or leaving your property, so to speak, the way you want, to the persons or organizations of your choice, at the lowest possible cost. This is one very basic definition that I learned a long time ago, and I've always defined estate planning like this, generally speaking. Estate planning is about disposing of your property the way you want to the persons or organizations of your choice at the lowest possible cost. Jeff, I'm going to stop there for just a second. I probably think there's not any questions at this point, but I just wanted to make sure.
Thanks, Steve. We actually do have a couple of questions, and I will go through them. So we have one from our good friend, Joe Sperling. He says, good morning, Jeff. Does the firm work with residents of Virginia? Thank you very much.
Oh, thank you for that question, and good morning, Joe. The answer is yes, we do work with residents of Virginia on a limited basis. None of our attorneys at Elville & Associates currently are barred in Virginia, but with the appropriate collaboration and co-counsel with a Virginia attorney, we many times can work with Virginia residents, and that we could talk about that. Thank you.
Okay. A somewhat specific question, so we'll see how you would like to answer this. The question is, I'm 84 years old with a life insurance that has a cash value of over $100,000. Should I continue to pay the premiums, about $300 a month, or cash it out?
Well, sir, that's a great question. Thank you for asking. The fact that you have diligently saved in your life insurance policy and kept that policy going all these years shows that you're very committed to that policy. And then we get this question many times with folks that are getting older and they've done such a great job with their life insurance. So this is going to be a question specific to your circumstances, your financial life overall, and it would not be something that we could answer or give advice about over this webinar. However, the basis of the answer of that question is really going to be comprehensive. It's going to be, what is your financial life look like, your financial affairs, versus your need to keep this insurance, what your goals are, and whether or not it would be advantageous to just go ahead and cash it out. So those are very common questions as we continue to see life insurance mature over the years. So we would be glad to sit and talk to you about that, or have a Zoom call or whatever is necessary to help you answer that question. That's a great question.
Okay, and those are all the questions we have for now. Thank you.
Thank you, Jeff. Okay, so let's now get into the second phase, I guess, of our presentation, which is probate versus non-probate. Now, this again is one of the most common questions, and a will, by its very nature, is subject to the probate process. Now, Mr. Sperling just a moment ago asked about Virginia. My understanding is that Virginia has a very limited probate process, and very much easier than Maryland, for example. But in Maryland, we have a full-fledged traditional probate process for the most part. And what we're seeing here in this slide is that probate basically is the public oversight. It is the process of proving a will to be valid. Now, if someone has a will, that will has to be proved to be valid in probate, and basically then after a period of time, and usually in Maryland it's about 9 months, usually, not always, the estate can be distributed. So creditors have to be notified. There is an inventory due. There's an accounting that's due, generally speaking, unless there's modified administration. And the cost of probate nationwide, according to AARP magazine, is 4 to 7%. I was speaking to an attorney in a meeting on the West Coast recently, and he's from North Carolina, actually, and he said that probate in his state was around 5%. I personally believe that in Maryland, the average probate costs around 4%, but there are some variables on that. That's not written in stone. But the idea here is that if you have a will, your will by its very nature is subject to probate. If you have no will, then you may have assets that are subject to probate. So let's talk about very quickly, what are probate assets? And I want you to ask yourself these questions, or quiz yourself, I should say, on these questions. So let's say someone has an IRA and it has a beneficiary. Does that go through probate? And the answer is no, because that is a beneficiary designated asset and it actually has a beneficiary. Now, what if someone has an IRA and does not have a beneficiary? Does that go to probate? And the answer is yes. And the same would be true of a life insurance policy. Now, switching gears to non-beneficiary designated assets, does a house that is owned as husband and wife or wife-husband, tenants by the entireties, does that go through probate? And the answer is no. That's a joint asset. It goes to the surviving joint owner. What if a single person owns a house, or even a married person owns a house in their own names? At their death, does that go through probate? And the answer is yes. Generally, that's the case. So we know that beneficiary designated assets, if they have a beneficiary, they do not go through probate. Assets that are owned in a person's sole name with no joint owner, those assets do not go through probate. Now, this is what a will structure looks like. So those of you who are on this webinar and you've never done planning before, this is the basic structure. We have the will, which is the driving force, but we know by its very nature, If we have probate assets, this will is going to control those assets. It's going to drive them down to your beneficiaries, and it's going to be subject to the probate process. Now, notice on the outside, these are what we call the ancillary documents. These are powers of attorney, advanced medical directives. These are the incapacity planning documents. So a good estate plan is going to talk about the will, what happens at death, that's stage one, and stage two, what happens during life, or at the same time, what happens during life. So what happens at death, what happens during life. We're going to talk more later about the powers of attorney. Now, the revocable living trust brings up the subject of non-probate. So wills are probatable, or if we have no will, the state of Maryland, if you're living in Maryland, will have what they call the intestacy laws, the laws of intestate succession, and that's going to dictate how the assets flow down to the beneficiaries, even if you have no will, but you had probate assets. Now, the alternative, as we start to look at these non-probate alternatives, is a revocable living trust. Some of you on this webinar have a revocable trust already. Some of you who have either no planning or you're thinking about planning, you may want to consider a revocable living trust. This is nothing more, and I want you to remember this now, this is not rocket science. It seems like a complicated thing, but a revocable living trust is nothing more than a substitute for a will. When you're looking at estate planning, you can have a will-based plan, or you can have a revocable trust-based plan. These are the two basic documents in estate planning, and the only difference is that the revocable trust is a will substitute. It is in essence like a contract. You're creating a private agreement, and this is a creation of the law that's been around since the late 1980s or early 1990s. It's very popular, and there are things that it does very well. The person who wants this particular kind of plan is a person who says, my goal is to avoid probate. I don't want my loved ones to have to go through the probate process, and I have people I can trust. I have a trustee that I can trust, whether it's my children or my spouse or my siblings. I have a private plan and I know it will be carried out. So that's a revocable living trust. There's nothing scientifically complicated about it. It has two phases. The first phase is to create the trust, and you'll see here in this illustration, the revocable trust now has replaced the will, and it is the driving force. So the revocable trust is designed through a process, through education, and you having all of the information you need to make the proper decisions. And then the second phase of the trust is that it has to be funded. It has to receive your assets. So non-retirement assets like real estate that is your primary residence or your second home, stocks, bonds, mutual funds, cash, money market accounts, savings accounts, even U.S. savings bonds are retitled into the name of the revocable trust. So the two steps are, we have to create the trust, make sure we've designed it properly, and then we have to fund the trust. It's not funny, but about every three months or so, we see people coming into our office here from various places in Maryland, and they have revocable living trusts that are not funded. These are people who were not educated through no fault of their own, or they were not assisted through no fault of their own in getting their revocable trusts funded. So they went through phase one or step one, but they did not take step two. So what happens is that person's estate plan is not going to work the way they want. The assets that are supposed to be within the revocable trust are not titled in the trust. Those assets remain outside the trust, and then those are going to go through probate. So a revocable trust is a wonderful tool, and it is the right choice for many people, but it must be developed and designed properly, and it must be properly funded, and then it should be maintained, as we've talked about. Now, we know a little bit about what a revocable trust is, but what is a revocable trust not? Well, it provides no asset protection. So when we're talking about asset protection, we're talking about protection from general creditors, lawsuits, car accidents, and suits stemming from that, divorce, making a bad business deal and being sued. All of those kinds of things are general creditor protection. And it provides no tax savings. So just because we have a great will or we have a great revocable trust doesn't mean that we've saved any taxes. But a revocable trust, if properly done, can minimize the cost of administration. So you'll see here that typically the cost of administering a revocable trust is less than probate, but this is going to have variable factors depending on how well you've maintained your revocable trust during life. So again, we want to make sure that we understand our goals. Is it important to us to avoid probate? Then we're probably going to use a revocable living trust as our structure. But if it's not important that we avoid probate, and if it's not important that we use the revocable trust as a tool for other purposes, which it does have a few uses for other purposes that are important, then we can use a will-based plan. The most important thing is that you have planned for what happens at death and what happens during life, which is the incapacity issue, which we're going to talk about in a few minutes. Now, there are assets that can be transferred non-probate without a revocable trust. And so many of you are familiar with these things: joint ownership, beneficiary designations, life estate deeds, transferable on death designations. Jeff and I were just talking the other day. Many of our wonderful financial advisor friends are actually doing estate planning that they probably shouldn't be, because they advise their clients to title their assets and in a brokerage account as transferable on death. And we know, as you're going to see in the next few slides, that those assets will actually not be controlled by the documents. And we'll leave that for now, but just know that there are various things such as payable on death accounts and so forth. There are various ways to avoid probate without using documents. So I want you to picture maybe 3 categories. In this category, we have wills, that's category 1. And in category 3, we have revocable living trusts, which we know are an alternative to a will. But in the middle category, we have these non-probate transfers that many of you are familiar with. And so let me just say in as short as I can, briefly as I can, that the reason most people use wills or revocable living trust is because those documents allow a person to control how things flow after our passing. Those documents allow assets to flow this way, or if circumstances have changed, to flow this way, or to flow into further trusts to protect beneficiaries, and so forth. These designations are more what I would call tools. These are tools that we many times use to get from point A to point B, but most of the time, these particular designations and devices, as I call them, they are not a substitute for estate planning. So that's a personal counseling issue, but it is clear that these particular types of non-probate transfers are available to use, but they do not allow you to control future circumstances and contingencies. So we can talk about that at another time. Those are the 3 major ways of transferring assets. Now, I mentioned just a few minutes ago that you could have a great will or great trust, but look at how assets actually transfer when we use these non-probate devices. And I want you to take this slide literally. We've got this great will, I've got this great trust. Doesn't matter how little or how much we paid for it, it's a great document. But now we pass away, and look at how the assets are transferring. They're transferring to the beneficiaries, which might be okay, but they're not being controlled. These assets are not being controlled by the trust or the will. These assets are passing outright to the beneficiary in these examples. Here's another better slide, possibly. Here we have the same exact situation. We have a wonderful will or trust, but the assets were not titled properly. So remember, in the revocable trust plan particularly, we have to make sure, and the second step is that the assets are funded properly, or titled properly, or beneficiary designated properly. Here's an example for those of you who may not understand what I'm saying. Let's say that it was important to me to leave a trust for my granddaughter. or to leave a trust for my son who had some issues. Maybe I just wanted to give him asset protection because he's in a high-risk profession. Or maybe I had a special needs grandchild or child, and I wanted to leave assets into that trust. So here, if I had a great trust or a will, and that great trust or will provided perfectly for my loved one, and it had this wonderful protection for them, but then I passed away not knowing that how my assets were titled really was going to control where those assets flow. So the trust that I established for my son or my daughter, my granddaughter, or my special needs loved one, that trust failed to receive the money that I had left. So we have to really be careful, whether it's wills or revocable trusts, we have to be careful how the assets are actually owned, and are those assets going to flow the way we want. It may sound too simple, but I will say that since COVID-19, it's been my experience that we have to worry about this issue more than we did before, because many financial institutions are somewhat scattered. Some of them do a great job, some of them don't. And what we have to make sure of is that simple things like our beneficiary designations and how assets are going to flow on the death of one spouse, or on the death of the survivor, or on the death of a single person, how are those assets actually going to flow, and is the plan properly structured for the assets, not just the documents? Okay, Jeff, I'm going to stop again, and we're getting ready to get into incapacity planning just to see if there's any questions.
Thanks, Steve. We do have one more question. And please, everybody, if you do have questions, let them come on in. Always happy to answer them. So the question is, one we've seen before, and it's a good one. After establishing my planning in Maryland, should I move to another state? Will the planning be valid? Is there a plan that is valid in all 50 states?
Thank you very much for that question. So the answer is that your will, if it's properly executed, that will is valid in any state through the full faith and credit clause of the Constitution. Now, with that said, some states have extra attestation requirements. For example, my understanding is that Virginia has a self-proving affidavit that must be attached to the back of the will. So if we know someone is moving out of state or there's a potential for that, we always add that extra attestation clause to a will. A revocable trust can be transferred to any state because that involves simply transferring the situs, which is the location of the trust, to the new state, and changing the law of the trust to the new state. So if you move to Florida, your revocable trust becomes a Florida trust, not a Maryland trust. So the answer is that properly done, and then in the modern world, your revocable trust would say, yes, it's okay to transfer this trust from one state to another, and here's how you do it. So yes, these documents today are portable. Now, segueing into incapacity planning, the powers of attorney and advanced medical directives that we're getting ready to look at, each state has their own code or statutes for these documents. Now, as we start to look at incapacity planning, and I'm going to go along the lines of that question, a financial power of attorney in Maryland should be usable, especially the statutory power of attorney, should be usable in the new state, according to the Attorney General of Maryland. And a Maryland advance directive should be usable and honored in the new state. And it probably would be. But if it were me and I were moving to a new state and I was going to never come back to Maryland, so to speak, and I was going to live in that state for the rest of my life, I would make sure that when I move to the new state, that these documents get updated. They're generally not very expensive to update. If you move to Florida, Texas, or another state, we want to make sure that we get powers of attorney and advance directives for those states. Now, incapacity planning is hugely important. Yes, Jeff.
Can we maybe address another question or two before we move on? We had a couple come in.
Sure.
So to piggyback on that last question, the question is, how does this apply to DC? So would that also apply to DC?
Yes, it would apply to DC because even though it's right next door, DC has its own powers of attorney and advanced medical directive documents. DC also has supported decision-making, and they have their own supported decision-making documents. But if we moved from Maryland to DC, we would want to make sure that our documents, if we have wills, have extra attestation. I am not barred in DC, but we would definitely want to make sure that whether it was DC or whatever other jurisdiction, that you have the full attestation on the will. The revocable trust, the same principle would apply, moving to another jurisdiction or district like the District of Columbia, that you would want to change the situs and location.
Okay, and one more briefly. My wife and I have a joint checking and savings account. We also have a revocable trust. Should we include the bank account into our revocable trust?
Yes, well, as a very general answer, and not knowing your trust or that situation, I'll just give a very broad general answer, which is not legal advice, I'm afraid, over the webinar. But generally speaking, a joint savings account would be retitled in the name of the joint trust, because the joint trust, depending on how it's drafted, is really kind of like the same thing. It's almost as if a traditional couple that has joint assets would feel very comfortable with a joint trust, because it still somewhat feels like joint ownership. So my non-official answer, general answer, is that would be what you would generally do.
Okay, thank you, Steve.
Thank you, Jeff, for bringing that up. Okay, so nothing could be more important today than incapacity planning. I would say about 3 months ago, I had a man in my conference room here, in the conference room where I'm sitting in Columbia, that was 105 years old. And I've had many folks that are in their mid-90s going back and forth in our offices here, like they were almost like they were teenagers, but let's just say it was almost like they were 65 or 70. And I've had many, many ladies live to well over 100. And I had a man about 5 or 6 years ago live to 106. So many of you know people are living a very long time. Many people are focused on the advanced medical directive, but in general estate planning terms, could I offer to you that the power of attorney, the financial power of attorney, is arguably the most important document in estate planning. The financial power of attorney is the thing that provides flexibility or lack of flexibility, and generally we want as much flexibility as possible. The power of attorney controls assets that are all of your assets. If you have a will, the power of attorney controls all of those assets if you become incapacitated. The power of attorney controls outside assets if you have a revocable trust, and the revocable trust controls the other assets. But the financial power of attorney is hugely important. You'll see here that it avoids guardianship. It avoids guardianship of your property so long as you have agents. So that's why maintenance and updating of your plan is very important for your own self-determination, so that you never become the ward of a guardianship unless you absolutely had to if you were incapacitated. An advanced medical directive names your agents. It also says when the agents have power. It also provides for flexibility or no flexibility in decision-making, organ donation, final arrangements, and many other things. So these documents are hugely important. Remember, good estate planning is about what happens during life, which is these powers of attorney and advanced directives, and not just what happens at death. So it's what happens at death, what happens during life. Now, Maryland, like DC, excuse me, and like Delaware and like West Virginia, Maryland now has a statutory power of attorney. That means the power of attorney is actually in the law of Maryland, and if your agent, you are the principal, by the way, but if you give authority to your agent, that agent now has the statutory power to take care of your affairs. Why is that a big deal? Well, it's a big deal. As we go back to the prior slide, you'll see the statutory power of attorney. That's a big deal because the power of attorney in Maryland now is enforceable. It's enforceable by law, and it cannot be rejected. Think about this. If someone is using a financial power of attorney for you, generally speaking, that means you are not doing well. You are incapacitated or borderline incapacitated, and this person is taking care of you, paying your bills, taking care of your spouse or others who are dependent on you. The last thing we want is for a power of attorney to not work, for it to be rejected, or it fails to be accepted. We don't want that. So what this is saying is the statutory form is enforceable by law, and if the person who is presented with the power of attorney rejects it, then your agent can sue to enforce it and actually get attorney's fees. But the Maryland power of attorney is limited in scope. It is generally limited because it's not customizable. There's reasons for that. It does what it does. The legislature talked about making the power of attorney more substantial this legislative session, but chose not to. It serves a very important purpose, but it is not highly customizable in my opinion. So we generally use 2 powers of attorney, and this is going to be a foreign subject for many of you who think in terms of having 1 power of attorney document, but we have a set of powers of attorney as our approach to try to provide the maximum power. But the Maryland statutory form, I won't spend time on these particular bullet points, but when you go through these in your own time, you'll see that the Maryland statutory form does not build, in my opinion, enough flexibility, and it does not give enough enhanced powers, and therefore we need to use 2 powers of attorney. So I'm not going to spend a lot of time on that. I just want you to know that concept. If you haven't had your powers of attorney updated, it's very, very important to do that. Some people think that the advanced medical directive is the most important of all documents. We want to encourage you to customize the advanced medical directive. We want to encourage you to really think about this. This is your preferences. These are your customizations. Now, if you don't customize the advanced directive, is it going to be the end of the world? No. As long as you have one and you've appointed your agents and you're letting your agents know generally what your wishes are, then we're very happy. And you've named enough agents in that document. But if you take it to the next level, here's my advice. Remember, the person who is trying to make your healthcare decisions, they only know what they see in this form. And beyond that, they only know what you've spoken to them about during your lifetime as your ideas, your thoughts, your values. So to the extent that you can take this slide and take a look at what I've listed here, and you can see that the advanced medical directive is customizable. There is no one form. Some people prefer a form called the 5 wishes. That is something you can find on the internet. And there are certain religious bodies that set forth their views and mandates about advanced medical directives and the end of life considerations. So this is a very broad subject. The Maryland Advanced Medical Directive is very highly customizable, which is why we use it. And we try to keep it simple because it's easy to read. It's easy to see what a person wants in these documents, and we try to customize them as much as possible and encourage you to do so. The MOLST form, which we won't spend much time on today, continues to evolve. The MOLST is a doctor's order. It is signed by a doctor or nurse practitioner. Many of you on this webinar may have a MOLST form or have loved ones who live in a facility or a continuing care retirement community, and they have a MOLST form. This is beyond today's discussion, but just know there is some counseling to be done, counseling issues, I should say, from the legal point of view, not the medical point of view, from at our conference table about the difference between advanced medical directives and MOLST forms and how they relate as we think about Maryland healthcare decision making. And Jeff has an excerpt from a video that we're happy to send to you. Life Care Manager Jill Rossner, who is very well known in Central Maryland, weighed in on the MOLST form and her views of it and the evolving aspects of the MOLST form. If you would like to see that, I'm sure Jeff would be glad to send that to you. Okay, Jeff, we're getting ready to get into the shift now from the concept of estate planning, the process of estate planning, the difference between wills and trusts, probate versus non-probate, incapacity planning, but I skipped over the fact of other non-probate transfers and how to look at those, And now we're getting ready to shift gears into tax. So Jeff, unless you interrupt me, I'm just going to keep on going so that we can end on time.
Okay, one brief question, if you will. The question is, if someone resides in Maryland, may their two powers of attorney live in other states?
Thank you for that. In my opinion, that's a wonderful question. In my opinion, if you may be asking that question because you may own property in another state. So in my opinion, there's no reason, as long as it doesn't cause confusion, in my opinion, there's no reason why you can't have a set of documents in Maryland for financial powers of attorney, even advanced directives, and also have a set of documents in another state because you may spend time in that state. The lack of or no cause of confusion part comes in just making sure that not only these don't get mixed up and that they are understood by your fiduciaries, but also to make sure that in the drafting of these documents that it clearly states that they do not supersede or cancel one another. That's a great question. Thank you. All right, we are living in a very advantageous tax environment still since the 2017 Trump Tax Act. And with regard to estate planning, we have unprecedented exemption amounts. So many of you are aware of this at this time, but many of you are not. So I'll just go ahead and tell you. On the federal level, it is possible for any person to leave $12,060,000 worth of assets to their loved ones. And for a married couple, it's 2 times $12,060,000 or $24 million. And on the Maryland level, Maryland is a state that has a state estate tax and an inheritance tax. We're one of the only states that has both. But Maryland's exemption is $5 million, which is unprecedented, $5 million per person. But if I skip down to portability, for those of you who may not have heard of portability, portability has been around now for 8 or 10 years. And it basically means that if you're married, and I apologize to the single people on the call, if you're married, it is easy to do tax planning between spouses. Now, let me tell you what that means. Let's say this spouse dies first, and that spouse, when they passed away, they had a $12 million estate tax exemption for federal estate tax. And why is that a big deal? Well, it's because the federal estate tax is 40%, and it used to be 55% when I was a young lawyer many years ago. So it's still very substantial. Now, that $12 million exemption, if it has not been used by the deceased spouse already, that, if you're married, will flow to the surviving spouse if he or she elects portability. And portability is a tax election that is done after the death of one spouse, and the government used to only give us 9 months, then they changed it to 2 years, and now the most recent change is the government is giving surviving spouses 5 years to use the portability exemption. So portability means that the survivor can elect to use not only his or her exemption, but the deceased spouse's exemption. And we don't have time to fully go into portability today, but this is a huge thing. It's like electing an exemption amount, and we don't know what the exemption amounts will be in the future, but it's like electing an exemption amount that is an heirloom. It is a shelter over the assets of the estate. So the vast majority of people, well over 97% of people, do not have assets exceeding $24 million. But there are people that do have assets of over $24 million, as you well know. So portability, in my opinion, is extremely advantageous for married couples. And in my opinion, subject to the particular situation of the couple, this should be used at the death of one person. Maryland also has portability. So it's possible for a couple to utilize the full 24 million and the full 10 million. Now, just to stop for a second, many of you may be saying, well, Steve, why would my surviving spouse need to elect portability if I have much less than 12 million? Why would she need or he need $24 million of exemption? Well, the truth is it may not be needed. But the other side of the coin is we don't know how much the surviving spouse's exemption is going to be. The exemptions are due to be decreased to about half of their level currently on January 1st, 2026. So the survivor of you may, if you're married, may only have half of what they have today. And if you can lock in the deceased spouse's exemption amount, it's going to be a tremendous heirloom for the loved ones to protect against the 40% federal estate tax and the 16% Maryland estate tax. Now, what happens in estate planning today? You can not only do tax planning through portability if you're married, but if you're married, you can also exercise control through the use of trusts at your death. Some of these trusts are called marital trusts. Other trusts are called non-marital trust. Most of the time today, the marital trust is going to be what is used to provide control for the deceased spouse. Why? To provide asset protection for the survivor and to also make sure the children receive the shares and to protect from a remarriage. So we have to make sure that if we're conscientious, we want to make sure that our surviving spouse, even though it may be wonderful for them to remarry, we want to make sure that depending on what your goals are, that we're protecting from a new spouse being able to get the assets. And well beyond today's discussion, but we want to make sure that if there is a remarriage, that the surviving spouse, I should say, is properly advised about a prenuptial agreement to protect the children based on new Maryland laws that would give a surviving new spouse, not only the surviving spouse, but the new spouse of the survivor, part of your estate if you're not careful. Now we're switching to, as we start to head towards the end of our presentation in the next several slides, we're looking at the difference between estate planning and elder law. Some people say, well, Steve, what is elder law? Well, as we can see, we're switching to the elder law discussion. Elder law is estate planning, but it has a focus on disability planning, nursing home planning, social security, housing, asset protection. So let's look down these bullet points. Asset preservation. How do I preserve assets that my family could preserve, but God forbid I might have to go into a long-term care facility, or even sometimes worse as far as financially, into a assisted living that's very expensive. I'm going to stop here for just a second. This is not the normal rule of thumb, but I have one client right now in an assisted living in the DC area, and the cost in assisted living, not long-term skilled nursing, but in assisted living, is $13,000 a month for a single person in an assisted living. So what we're trying to do in long-term care planning is we're trying to consider whether we want to do asset preservation. Do we want to provide for a divestment of assets? There are ways of giving away assets in a controlled manner with the use of Medicaid trusts and veterans asset protection trusts. There's ways of doing that. And when you see this bullet point here that says, well, I can control the assets as much as possible, but I can still hit several birds with one stone, so to speak, in the sense that I can accomplish tax planning, control, asset protection, and Medicaid protection in certain types of strategies. And that's what we want to explore. Back to flexibility, which I skipped over. Flexibility is one of the most important things in elder law. So I want you to think about elder law as housing, Social Security, Medicaid, assisted living, long-term care facilities, special needs planning between spouses, which we're going to talk about in just a second. And as we talk about asset protection now, and we head towards the end of our presentation, I'm going to talk to you in terms of three types, because asset protection is a very broad subject. There is lifetime asset protection. You may have asset protection that you didn't know you currently had. There is asset protection for long-term care. We just talked about that. And then there's asset protection at death. So in lifetime or during lifetime, if you are married, and I apologize to the single people, I'll get back to you in just a moment. If you are married and you own your assets, whether they are real estate assets or brokerage assets, if you own them as tenants by the entirety, you have a very basic level of asset protection. If you are married and you don't own assets as tenants by the entireties, you should be thinking about it. If you're married and you have, or single, I should say, and you have life insurance or an annuity, and your child or spouse is the beneficiary, then you have asset protection in life insurance and annuities. Qualified plans and IRAs. If you have a 401k, 403b, 457 plan, a qualified plan, or if you have an IRA, you have asset protection in those retirement assets. You cannot be sued and lose those, generally speaking. However, when we pass away and we leave inherited IRAs to children, nieces and nephews, grandchildren, those beneficiaries do not have asset protection. That is a new law over the last 10 or 12 years, and we have to assume that we would have to leave those assets into a trust, an irrevocable trust, to provide asset protection. Those are called IRA trusts, and we want to make sure we understand that you and I have protection during our lives in our qualified plans and IRAs, but our loved ones that we leave IRAs to will not have asset protection unless those are left in further trust. Domestic asset protection trusts, we're not going to focus on that much today, but it is possible to create a trust during lifetime, not necessarily in Maryland with a couple of exceptions, but in places like Delaware, Alaska, Nevada, South Dakota, Wyoming, places where there is asset protection in statutes for people who want to create lifetime trusts. So that's just a subject for another day that you should know about. Now, switching back to elder law and long-term care, the use of Medicaid trust is a very powerful tool. The Medicaid Asset Protection Trust is arguably one of the most powerful tools in estate planning today. This allows you to do what I was mentioning just a few minutes ago, hit several birds with one stone, so to speak, by having all kinds of advantages and also retaining a certain amount of control over the assets that are gifted, to try to put ourselves past the Medicaid 60-month, 5-year period, which many of you have heard of. We might want to call that a look forward period. If we divest our assets, and by the way, you do have to divest your assets for Medicaid purposes, or there would be no protection. So you have to divest your assets, and we have this 5-year period to deal with. Same concept, but similar, not exact, with Veterans Asset Protection Trusts. In 2018, the VA changed its rules after many, many years. So in some ways, veterans planning for asset protection has become easier. And in some ways, it is diametrically opposed to Medicaid planning, and we have to take this under consideration. But these powerful trusts provide multiple types of advantages, and this is a counseling issue. Between spouses, it is possible to use certain strategies to protect assets if one spouse is ill. And unfortunately, we see many of those situations, and you have seen many of those situations where one spouse has an impairment, there's an illness, and Maryland, through something called the Augmented Estate Law, which is really called the New Spousal Elective Share Law, which we could talk about at another time, that has set forth that if we follow the appropriate strategies, Maryland has no recovery against a surviving well spouse when the proper planning is done for a spouse who enters a nursing home or gets on Maryland medical assistance, Maryland Medicaid. The rule of halves, just to skip down to the bottom bullet point, the rule of halves is a strategy most people are not aware of, that if there is a surviving person, a single person, and that person has a certain number of assets, many of those assets can be saved. Up to 50% of those assets can be saved based on certain Medicaid strategies that are allowed under the law. Life estate deeds are a simple way of maintaining a life estate, the right to live in a house, but transferring the remainder of that house to loved ones. That starts the 5-year period. So many times that is a low-cost way of doing asset protection, although it doesn't really, it doesn't provide much flexibility. So that's the problem with that strategy. And in the interest of time, as we go to the last part or last bullet point about asset protection, this is possibly the easiest type of asset protection, even though it's, I'm not trying to be funny about it. When we pass away, it is actually easy to protect the shares of spouses, children, grandchildren. And that is because if we have a healthy beneficiary, we can leave what is called a spendthrift irrevocable trust. We can leave a trust where that beneficiary has protection from creditors of all kinds, car accidents and tort claims, a divorcing spouse, and so forth. These trusts protect mostly against all creditors, with three exceptions. The trusts do not protect against an IRS lien, but Uncle Sam has to get pretty upset to be able to get in one of these trusts. So generally, we're not that worried about Uncle Sam, but it does not protect against child support or alimony claims. But these are very popular trusts at death or during life. These trusts can be created. The trust can have beneficiaries having a large amount of control. Structuring trustees. We do a whole workshop on trustees and how to select trustees. And so I strongly recommend that you look at that workshop or attend the next one, because structuring trustees is arguably the most important of all planning decisions. The use of a trust protector. This is beyond today's discussion, but a trust protector allows a trust that eventually becomes irrevocable. It allows that trust at death, whether it's a special needs trust, whether it's a general needs trust for a spouse or another loved one, it allows flexibility in that trust. So trust protectors are not required, but we strongly recommend that as a design and education feature that you understand what trust protectors are and what they do. Now, as we really get toward the very end of the presentation, thank you for your patience and your attention. We're going to just say a few words about the Secure Act. So at this point, 2 years later, many of you know what the Secure Act is. The Secure Act was signed into law at the end of January, at the end of 2019, became law January 1st, 2020. And if you have an IRA, it's probably going to affect your estate plan. What it basically means is that unlike in the past, when we received an IRA from someone, an inherited IRA, we could stretch out the taxation for our entire lifetimes. Many of you on this webinar have received an IRA from someone, and it was prior to 2020 when the law changed. And fortunately for you, you're able to stretch out the taxation based on the required minimum distributions over a long period of time. And if you don't need the money, you can stretch that money out until your mid-80s, basically. But that all changed with the Secure Act. And now, as you may have heard, healthy beneficiaries that are non-disabled, non-chronically ill people, those people only have 10 years, and that's the vast majority of people. So 10 years they have to completely deplete an IRA. So the IRA must completely be distributed out within 10 years. Uncle Sam basically is taxing trillions of dollars of IRA money on a much more accelerated basis. So that's what we're dealing with. Not good for clients. Fortunately, there are 5 exceptions. I'll just give you those. It's spouses, minor children, people who are less than 10 years younger than you. This could be an older sibling of or someone like that. Chronically ill people and people with disabilities. Now, fortunately, for people with disabilities and chronically ill people, a supplemental needs trust is also exempt. So we just have to understand that certain people are exempt and they will be able to stretch out their IRA taxation, but many people, most people will not. So all plans generally need to be reviewed, and there are certain limited strategies such as Roth conversions and life insurance as a tool to deal with IRA accelerated taxation. Special needs planning needs to be carefully looked at to make sure that the beneficiary inadvertently does not have to be paying all the tax at once. Make sure that those special needs trusts and others are properly optimized. Now, as we start to wrap up, Elville and Associates tries to educate, and that's our mission, but we believe in, as I said earlier, we believe in not only educating, but also giving you a path forward, not only to become a client and to get your planning reviewed or to get your planning started, but also to maintain your plan. So just know that you can read about this at another time. Elville and Associates is one of the only law firms in Maryland that has a client care program, and we are a member of the Client Care Academy. We developed our own client care program in conjunction with the Academy, And we're very proud of it. And it is a way that we are offering clients a way to basically just keep this in mind, keep the planning in mind, keep awareness of the planning, and also to provide education for children, fiduciaries such as personal representatives under wills, trustees, guardians, trustees for children who are receiving trusts, educating children about trusts and about their parents' planning, educating fiduciaries about how to take care of a special needs loved one. This is the goal of our client care program. And we also have a social event once a year. And I won't go into all the details of the client care program because we're going to wrap up, but I just want to encourage you to try it, to see if you like it, and to understand that our goal is really just to make sure that you are keeping in touch with your estate plan and that you're not losing touch with it over the years, so it will actually work the way you want. So I'm going to skip through these slides. And as we wrap up, Jeff, I'm going to hand it over to you in just a second. We want to encourage you now, having set through all that information. I appreciate your attention, and I hope you made notes. I hope you have questions. We want to provide a path forward for you. So we encourage you to not only educate yourself, but to go ahead and set a consultation with us. We are here in a relaxed environment in our offices, and we have very modern tools, electronics in our conference room, everything that you would need to relax. We don't want you to fear anything. There's nothing to fear. Everything here is confidential when you come in to talk to us. We want you to bring in an estate planning questionnaire. This is a little bit of work on your part, but remember, if we don't know about you, we can't really help. So the more that you will participate with us in filling out this questionnaire, this can arguably be one of the most important things as part of the process, is that estate planning questionnaire. We want you to bring your current estate planning documents. Please bring them in. We don't charge generally to review your documents, to let you know what we think and to give you an opinion about these documents. And for those of you who don't have documents, you don't have to bring anything in except yourselves and maybe the questionnaire if you do have time to complete it, and anything else you want us to consider. We want you to think about whether you have an advisory team. Do you have a financial advisor? Do you have a certified public accountant? And we want you to write down your questions. We're very used to answering questions. Many people come to Elville and Associates to get their questions answered because they know that we will actually try to help them, and they have lists of questions or concerns that you've had for years. We want to encourage you to come in, and don't be afraid at all to come in with that list so we can talk. But the most important thing that we want to do is we want to give you the time to think. We want to give you the space to think. We know the world as it is a very fast-paced environment. Many people do not have a lot of time for these considerations. So we want to walk you through a counseling discussion, a process that will help you identify what your goals are, and then you can move forward confidently, knowing that you are being educated and that you're getting all the contemporary information about estate planning. So whether you're speaking with Jeff today about setting a consultation, or you can email me directly, or you can email my longtime assistant, Mary Gay Kramer, we at Elville and Associates are here to help you. We have 5 attorneys, 2 special counsel attorneys, and around 20 employees with various offices. So I thank you for your attention today. I hope that we can answer your questions and consult with you. Jeff, I'm going to turn it back to you.
Well, thank you, Steve. Really nice job as always, and couldn't have said anything better myself. We're here to be a resource to you, and really do a focus on education and counseling and giving you a path forward and creating some peace of mind to our clients along the way. So thank you for being here today. We do have some questions that we want to have answered for you. And if you do have a question, now would be that time to get that last question in for Steve today. Appreciate the questions. They've really certainly added some good value to the already great presentation Steve has offered here. So we've got a few minutes left here and we'll get to it. So the first question is, what if my agent lives in another country? Any thoughts on that, Steve?
Thank you for that wonderful question. I'm going to say that I have seen this several times. It's going to be factual circumstances and whether this is practical. But I will tell you that at times a person may not have any choice. Maybe the only reasonable person to be your agent lives in another country. I once had a client not so long ago that had only one healthcare agent, which I never recommend just one, but this was the primary person, and that person was living in China. And so the good news was that cell phone service is very good there. So I would say this is generally not going to be an obstacle as far as communications, overnight mail or email or cell phone connections and so forth. So this is not generally a problem as far as communications. What happens is, it can be a practical obstacle for the exchange of paperwork or other things. But then today we've got electronic signatures. Many documents can be completed electronically. I would say it's not ideal, but it certainly is not something that can't work, and I've seen it many times. So I would not worry about it. I think if that is the best choice for you, that is going to work as long as communications are easily available.
Okay. Next question is regarding annuities and IRAs, both of which have beneficiaries. Are we saying assets aren't protected from probates or not protected if the owner of those accounts need medical care?
Okay, that's a great question. So first, I think there's two parts of that question, if I heard it right. One part is an annuity or IRA going to go through probate? Now, the answer is if there is an individual beneficiary named, or a beneficiary named, I should say, then there's not going to be any probate. If that beneficiary survives or that beneficiary is a charity, there's not going to be any probate. But what happens is today, it's easy to forget these fundamental things. Prior to COVID, I was sitting in my conference room and I was sitting with a couple in the normal course of business. And one of the spouses looked at the other and said, my goodness, I've just been reminded that I don't have a beneficiary on my $1.6 million IRA. Now, of course, that was not uncommon. Sometimes this happens. But the good news is that person fixed that situation. The bad news is that if that person had died, then that 1.6 million would have gone through probate, and that's not supposed to happen. So the income taxation would have been accelerated to 5 years or less, and in practical terms, the whole thing would have been taxed immediately under the estate. So that's the first aspect of the question, which I understand, which is there will not be probate if there is a beneficiary. There will be probate if there is no beneficiary. And Jeff, could you read the question again so I can get the last aspect of it?
Sure. Regarding annuities and IRAs, both of which have beneficiaries, are we saying assets aren't protected from probate or not protected if the owner of those accounts needs medical care?
All right. Now, if I'm taking the last aspect and then I'll finish, I'm assuming you mean if this person needs medical care or even long-term care, are these assets protected? So first of all, if there's a beneficiary, it's protected from probate and the accelerated taxation of an IRA. But if a person needs medical care, and let's just assume it's long-term care, then these assets are not protected from long-term care costs. And it's very hard to plan around IRAs. IRAs are troublesome for long-term care planning. We just have to deal with them. Annuities are a bit more possible to do planning for long-term care. So IRAs and annuities are generally not protected in Maryland from long-term care or medical costs, but they are protected from the claims of creditors, not medical creditors or medical costs, but they're protected from general claims of creditors. If a spouse or a beneficiary of an annuity, a spouse or a child is the beneficiary of an annuity, and in general, the IRA is going to be protected from general creditors. I hope that helps.
I certainly think so, Steve. Thank you. So we've got a few more here, so we'll get moving here. How much do you charge to set up someone's estate plan? Any comments on that? Steve?
Yes, thank you for that. Most estate planning is done on a flat fee, and at Elville and Associates, we have different tiers of pricing for that. So we'd have to look at your particular situation and what you need. There are times when we do amendments or updates on an hourly basis, and we're happy to send you our fee schedule and our hourly rates for that. Sometimes elder law planning is done on a flat fee at our firm. Sometimes it's done hourly. So it just depends on your situation and what type of estate plan we would be doing, whether it is a new plan and whether it's a will or trust-based plan, or whether it is an existing plan that we need to amend. So I have to leave it at that. Jeff would be glad to send you a pricing sheet of our flat fees and our fees in general.
Sure.
And what we do at Elville and Associates is we don't charge for estate planning consultations, and we generally don't charge to review documents. And we spend about an hour and a half so that we can get to know you, give you some idea, give you the idea of what we think we should do, and that's when we usually discuss fees.
Very good. Next question, are Roth IRAs also affected by the Secure Act?
That's a great question that we often get, and the answer is yes.
Okay.
I will say,
Often...
sorry, Jeff, just one more comment on that.
Yeah.
I will say that one of the advantages of the Roth IRA, obviously, is that it does beat Uncle Sam, so to speak, defeats Uncle Sam's new law in the sense that if you have been able to move or transition most of your assets or establish most of your assets in retirement plans in a Roth, that is the best strategy to outwit Uncle Sam, I guess, with the Secure Act. But the Secure Act does affect that plan generally, even though Uncle Sam cannot accelerate the income tax.
Okay, I have a question from a financial professional, Mr. John Hinkle. Welcome. Do you have an office in Montgomery County? I have many clients there. I'm a financial professional.
Yes, sir. Thank you for that question. We do have 2 office locations in the Rockville area, and we can meet clients in the north or in Bethesda. So we have an office at downtown Rockville, there near the old theaters and the courthouse, and we also have one on Mid-Pike on Rockville Pike.
Okay, thank you. I have a repeat of the question, what if our adult children or agents live in another country? So I think that we've answered that. Yeah, let's see here. A question, who in Virginia does what you do? Well, I don't know if you want to comment on that, Steve. I can say if we can certainly co-counsel with attorneys to get planning done. If there's a need for a referral for certain types of situations, we can certainly provide that. Do you have any other thoughts about that, Steve?
I just want to say, obviously, there are many fine estate planning attorneys in Virginia. We would have to find out where you live and get you connected with someone that's suitable. And on the elder law side, of course, Virginia's laws are different than Maryland, similar but different. And there are certified elder law attorneys is who we would recommend for more elder law type issues. And we usually refer out on a case-by-case basis and work with you to do that.
Right. And the same person said, how to find an administrator if no relative lives near me?
Gotcha. Well, that, sir, is a wonderful question, and sir or ma'am, that's a wonderful question that has to do with trustee selection. And you're welcome to view this workshop that we give quite often about trustee selection. And in that workshop, you're going to see, or you'll attend the next one, you're going to see, or we can advise you in person, you're going to see that you have choices about individuals or independent trustees that are not relatives, independent banks or other trust companies, or a combination of those, or even your attorneys or CPAs and so forth. So what we try to do is work through issues like that on a case-by-case basis to come to some kind of reasonable conclusion. And it's not uncommon for clients to struggle with this a bit and to interview trustees and to really think through. Elville and Associates, we have what we call our Waypoint Fiduciary Services, which is our trustee services. We're not a trust company, but we do serve as trustees. But we may not be suitable for your situation. We may or may not be. And so we always talk in terms of giving you the choices of corporate independent trustees or other independent trustees if you don't have family members.
Okay. Next question, do you work in Massachusetts or could recommend someone there? Again,
Yes. Yes, thank you. It depends on where, but I don't think Massachusetts is that big, relatively speaking. So yes, we have one or two really fine estate planning and elder law attorney contacts in Massachusetts, particularly obviously around the Boston area, but outside of Boston too.
Yeah, so if you emailed Steve or myself, we could certainly provide a good referral to you based on where you live. Next question, we just moved to Delaware from Maryland. We have a revocable trust executed in Maryland. Should we redraw our revocable trust?
Great question. It depends on a lot of things. It depends on when you last did your trust. It depends on, if you need a general update. But I would say yes, because if you have a revocable trust, not knowing your situation, it just sounds like you would typically restate that trust. And at the same time, you're maybe hitting two birds with one stone. You're restating the trust, and you're also saying, my trust has now moved to Maryland. I've changed the situs and location, basically, and I'm now declaring that this is a Delaware revocable trust and not Maryland. So I think you can, depending on when you did this, you can restate the trust and kind of hit two birds with one stone. Or if you just recently did your planning, it may not need a general update. You just need to change the situs and state law.
So we have a couple more. I know, Steve, you've got an appointment coming up. Just a couple more. Our initial consultation is free, and how much time is afforded to a person at the free consultation? And can you have your initial consultation specifically with Steve Elville?
Oh, thank you for that question. So the answer is our estate planning consultations are no charge. We usually spend 90 minutes or less in those, but typically it's 90 minutes. And yes, you can request me specifically, and I'm happy to meet with you. Thank you very much for that. The only consultations we charge for generally are elder law type consultations, because those are more immediate concerns, and we have to charge for those, but we don't generally charge for estate planning.
Okay. If a deposit savings account has a POD added, is that account also protected from creditors?
Good question. That account will not be protected from creditors unless it's titled as tenants by the entireties if you're married. If you're single, it generally doesn't have any asset protection unless you take further action to move that money into some other vehicle.
Okay. Is there a way to protect your spouse from inheriting your college loan debt?
Oh my goodness, that is a question that I think is beyond my knowledge today. I don't know the answer to that right off the top of my head. We'd have to have a paralegal research that. I get the feeling that my first reaction would be, I don't think your spouse is responsible for that, but I'd have to have someone research that. I apologize.
Yeah, send that question to me and we can get it researched. Please, jeff@elvilleassociates.com. Last question, then we'll wrap up. What is your typical client base? High net worth, private wealth, family offices? Any thoughts on that last question, Steve?
Well, thank you for that. I think not to just be intentionally ambiguous about it, but the truth is that we are estate planners, special needs planners, and elder law attorneys, and we have a vast array of clients. So we don't necessarily have just all high net worth clients. We have all types of clients. We can have wealthy clients that have special needs children. We have not so wealthy clients that have the same situation. We have young families that are just getting started. We have middle-aged families that have never done planning. We have families in crisis. So unlike some practices, let's say, that might focus on, let's say, extremely wealthy clients, the honest answer is that Elville & Associates has all kinds of clients, just because we are a hybrid practice of estate planning, elder law, and special needs. So I'd be happy to talk about that, and Jeff would be happy to talk about that too. Thank you.
Sure. Yeah, we aim to be a resource to everyone here at Elville & Associates. I think that's something we're very, very proud of. So let us know if you have any further questions. Thank you for all the questions. I'm just going to be very brief here since I know Steve has to go and we're a little bit backed up, but thanks to all the questions. I'll be sending out the MOLST information, the MOLST video, the slides, the Trustee Selection workshop, And then I'll also go through in my follow-up email. I always send out after our webinars some of our upcoming webinars that we have going on as well. We've got a lot of really nice ones coming up in the next few weeks. So I want to thank you for being here today. Thank you again, Steve, for your time. And thank you to all of our attendees for being part of our Elville webinar series and our estate planning essentials today. And we look forward to hosting you again soon. Have a really nice Friday and a great weekend, everybody. We'll talk to you soon.
Thank you, everyone.